Hello and welcome to Courts Today by Live Law. Let us start with today's top headlines. In the Sambhal Mosque Row, the Allahabad High Court has stayed the trial court proceedings till 25th February and sought responses from Union of India and Uttar Pradesh government. The Kerala High Court has held that calling a woman's body structure fine prima facie is sexual harassment. The petitioners challenging the Election Commissioner's new law have requested the Supreme Court to hear the challenge before retirement of the Chief Election Commissioner in February, saying that Domestic Violence Act cases have no penal consequence except for breach of protection order. The Supreme Court has criticized issuance of bailable warrants in a case. In a parent's plea to quash their daughter's 21-week pregnancy, the Bombay High Court has questioned, does a woman with below average IQ have no right to be a mother? And the Supreme Court has held that seized vehicle under NDPS cases is not liable to be confiscated if the accused used it without the owner's knowledge or connivance. I'm your host Urvashi Chauhan with your daily roundup of legal updates from across the country. Before moving ahead, let me tell you, Live Law Academy is offering a value-packed opportunity for the aspiring judges. The Judicial Service Examinations Preparation Course. This comprehensive online course is designed to help you prepare for your judiciary exams. The classes are conducted by expert faculty, including retired judges. You would learn from actual case studies and other easy-to-follow study material, and all of this comes at an affordable fee. If you are gearing up for the judiciary exams, then this is a must-check opportunity for you. Enroll today and you can also get 20% scholarship if you apply in the next 4 days. You can check all details at www.livelawacademy.com. The Allahabad High Court has today stayed the Sambhal trial court proceedings in a suit claiming that the Chandausi's Shahi Jama Mosque was built after destroying a Hindu temple. A bench of Justice Rohit Ranjan Agarwal passed this order on a civil revision plea moved by the mosque committee. The revision was filed challenging the trial court's order passed in November, which directed an advocate commissioner to survey the mosque to determine whether it was built after destroying a temple. According to the Hindu plaintiffs, the mosque in question was originally the site of an ancient temple. The survey by the court-appointed commissioner triggered violence on 24th November, which left 4 persons dead. If you remember, the trial court proceedings were stayed by the Supreme Court and it had directed that the trial court will not proceed till the petition filed by the Masjid Committee against the survey order is listed in the Allahabad High Court. Today, the High Court called for the responses of Union of India, ASI, UP government and the district magistrate concerned within 4 weeks. The matter will now be taken up on 25th February. Stay tuned. In the next update, the Kerala High Court has observed that a man making comments about a woman's body structure, calling it fine, prima facie amounts to a sexually colored remark. Saying so, Justice A. Bahaduruddin refused to quash the criminal proceedings initiated against the petitioner in this case for offences under IPC and the Kerala Police Act. While IPC Section 354A states that making sexually colored remarks would constitute sexual harassment, Section 509 talks about acts intended to insult the modesty of a woman. And Section 120 of the Kerala Police Act stipulates the penalty for causing nuisance and violation of public order. It was the prosecution's case that while the complainant was working at the electrical section of Kerala State Electricity Board, the accused made sexually colored remarks and overturns by commenting that her body structure was fine and that he sent messages with sexual overtures to her mobile number. But the accused petitioner here opposed the allegations, saying that mere reference that a person has a nice body structure would not amount to sexually colored remarks. Not agreeing to this, the High Court highlighted that any man making sexually colored remarks as these to a woman is guilty of the offence of sexual harassment. Also, the court observed that any act of causing inconvenience or annoyance through any means of communication by repeated or undesirable or anonymous call, letter, writing, message, email or through a messenger would constitute an offence. Considering the facts of the case, the court noted that the proceedings here were not initiated maliciously with ulterior motives. Thus, it refused to quash the proceedings initiated against the accused, dismissing his plea. And now an update on the pleas before the Supreme Court challenging constitutionality of the Chief Election Commissioner and Other Election Commissioners Act of 2023, which, if you recall, had removed the Chief Justice of India from the selection panel appointing election commissioners. The matter was today mentioned by the petitioners, and the Supreme Court has expressed an inclination to hear it on 4th February. The pleas were mentioned before Justices Surya Kant, Dipankar Datta and Ujjal Bhuya by Advocate Prashant Bhushan, appearing for the Association for Democratic Reforms. He emphasized the urgency of the matter, requesting a hearing next week. He explained that the case had been scheduled for February, but since the Chief Election Commissioner is retiring that month, a new appointment would be needed. The key issue is whether this appointment should follow the Constitution Bench ruling in Anup Baranwal versus Union of India or the new CEC Act. In Anup Baranwal case, let me tell you, the Supreme Court had ordered that until the enactment of a law by the Parliament in that regard, election commissioners shall be appointed by the President of India on the advice of a committee consisting of the Prime Minister, the Leader of the Opposition in the Lok Sabha and the Chief Justice of India. But the Act brought in later removed the CJI from the committee. This enactment triggered a cascade of litigation with Congress leader Jaya Thakur, the Association for Democratic Reforms and others approaching the apex court. Today, Advocate Bhushan further argued that by removing the CJI from the selection panel, the executive has acquired control over the appointment of election commissioners, which is a threat to electoral democracy. Senior advocate Gopal Sankara Narayan argued that the Baranwal judgment had clarified that executive cannot control the issue, but the enactment of the CEC Act by executive contradicts this, as it fails to address the core of the Constitution Bench's ruling. In response, Justice Khan today said that the court understands the importance of the matter, but important matters also require a good amount of time for hearing. The matter is likely to be taken up on 4th February now. Stay tuned to know further updates. Moving ahead, the Supreme Court has criticized the issuance of bailable warrant by a magistrate in a case under Protection of Women from Domestic Violence Act of 2005. Justice Sandeep Mehta remarked that there is no justification for issuing bailable warrants in cases under this act, as they are quasi-criminal proceedings and do not carry penal consequences unless a protection order is violated. In this case, the petitioner has been accused in a domestic violence case filed by her mother-in-law. She prayed for the transfer of the case from Delhi to Ludhiana. Her counsel argued that she has a specially abled son who suffers from hearing impairment, and she is unemployed and fully dependent on her father. She also told the court that the lower court had issued bailable warrants against her. The Supreme Court criticized the issuance of these bailable warrants and agreed with the petitioner, thus transferring the case from Delhi to Ludhiana. For your information, I must tell you here that the DV Act focuses on protecting women from domestic violence, offering relief and protection rather than punishing the abuser. It is a civil law with quasi-criminal proceedings, and criminal penalties only apply if a protection order is violated. Bailable warrants are generally used in criminal cases for non-compliance, but in domestic violence cases, the priority is safeguarding the woman and not penalizing the accused. Therefore, issuing bailable warrants is not appropriate in these cases. In the next update, the Bombay High Court today heard a plea from a sexagenarian couple seeking to terminate their 27-year-old daughter's 21-week pregnancy, citing her mental health issues. The daughter, who has borderline personality disorder and an IQ of 75, that is below average, was found to be medically fit to either continue or terminate the pregnancy, according to a medical board's report. During the hearing, Justices Ravindra Ghuge and Rajesh Patil questioned whether a woman with below average intelligence has the right to be a mother. The bench also emphasized that different levels of intelligence do not negate a woman's right to motherhood. The court noted that the daughter expressed her desire to marry the man who had impregnated her and refused to consent to an abortion. The judges criticized the parents for not reaching out to the man, urging them to take initiative and support their daughter. At the previous hearing, the court had reprimanded the parents for their parenting, highlighting that the daughter, adopted at 6 months old, was allowed to stay out late at night. The court adjourned the hearing to 16th January now, asking the family to contact the man and determine if he would marry the daughter. And lastly, the Apex Court has ruled that a vehicle seized under the Narcotic Drugs and Psychotropic Substances Act for the alleged transport of drugs cannot be confiscated if the owner of the vehicle can prove that it was used by the accused person without the owner's knowledge or connivance. The court clarified that the seized vehicles can be confiscated by the trial court only after the trial is completed. That is, when the accused is convicted or acquitted or discharged, and an opportunity of hearing to the person who may claim any right to the seized vehicle before passing an order of the confiscation has been given. The court was hearing the appeal filed against the Guwahati High Court's decision upholding the trial court's decision refusing to allow interim release of the appellant's seized truck. Setting aside the High Court's decision, Justice Manmohan held that the NDPS Act does not prohibit interim release of vehicles that are seized for allegedly transporting contraband. The court added that the seized vehicle here can be released under sections 451 and 457 of the CRPC. For more information on the cases that I mentioned, you can visit our website at www.livelaw.in. Your support means the world to us. So please do not forget to like, share and subscribe to our channel.